Kinds of contract. There are different kinds of contract. They can be classified as follows. According to enforceability. Valid contract. An agreement enforceable by law is a valid contract. An agreement becomes a contract when it fulfills all the essentials of a valid contract. In a valid contract, all the parties are legally responsible for the performance of the contract. If one of the parties breaches the contract, the other party can enforce it through the court of law. Examples: C agrees to sell his cars to B for 5 lakhs. B agrees to buy it. It is a valid contract. If C fails to deliver the car, B can sue him, and if B fails to pay, C can sue him. Void contract. The term void means something without legal effect. Section 2 states a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. It means that a void contract is a valid contract when it is made, but subsequently it becomes void due to certain reason. In a void contract, both our parties are not legally responsible to fulfill the contract. A contract becomes void under the following circumstances. Impossibility of performance. A contract becomes void due to impossibility of performance. A contract becomes void when it becomes impossible to be performed by any party due to any reason. Example: C agrees to sell his house to B. After 2 days, the house is born at the next day. The contract becomes void due to impossibility of performance. Subsequent illegality. A contract becomes void by subsequent illegality. If a contract is made between two parties, but before the performance of contract, a new law makes the implementation of contract legal, the contract becomes void. Example: C agrees to send acres or bags of wheat to B. Before delivery, before delivery of wheat, the government puts a bonds on private trade of wheat. The contract becomes void. Rejection of voidable contract. If the consent of one party is not free, the contract is voidable. The party whose consent is not free has the right to reject or accept the contract. A voidable contract becomes void when the party whose consent is not free rejects the contract. Example: impossibility of defending event. The performance of a contingent contract depends upon the occurrence, occurrence or non-occurrence of a certain event. It becomes void when that event does not occur. Void contract, void agreement. Void agreement. An agreement which is not enforceable by law is a void agreement. It does not create legal obligation among the parties. It is void from the beginning. In a void agreement, there is absence of any essential of a valid contract except pre-consent. An agreement with a minor and agreement without consideration are valid agreements. Voidable contract. The term voidable means which can be avoided or confirmed. It is not absolutely void. Section 2 states a voidable contract is a contract which is enforceable by law at the option of one party but not at the option of the other party. Unenforceable contract. It is a contract which cannot be enforced by the court due to some technical defects. The technical defects may be absence in writing, registration, stem, etc. When the technical defects are removed, the contract becomes enforceable. Examples: C boys are 1 billion from C get loan 1 billion from B and makes pronote on 10 stamps paper. It is impossible because the pronote is undervalued. Illegal agreement. An agreement is illegal if it is forbidden by any law. The object of illegal agreement is unlawful. It is void is unlawful. It cannot be enforced by the court. The parties to an illegal agreement are not responsible to perform their promises. There is punishment for the parties who make such agreement. According to formation, express contract. An express contract is a contract where the parties states the terms by words spoken are written at the time of its formation. When such a contract is performed, there is no difficulty in understanding the rights and obligations of the parties. Implied contract. An implied contract is made otherwise than by words spoken or written. It arises from the acts or conduct of parties or circumstances of the particular case. It arises when one person without request provides services and accepts to be paid for them, and the other person accepts those services. Examples: here we take the example, we went into a restaurant and had a cup of tea. It is an implied a contract, and B must pay for the cup of tea. Quasi-contract. A quasi-contract is not a contract. It is an obligation created by law in the absence of a contract. It is based on the principle of equity that a person shall not be allowed to get benefit at the cost of other. It is also called constructive contract. Example: C finds the lost goods that belong to B. C is bound to return the goods to B. According to performance, executed contract. In an executed contract, both the parties completely fulfill their obligation. It means that nothing remains to be done by either party under the contract. Example: B buys a book from C. C delivers the book and B pays the price. It is an executed contract. Is executory contract. In an executory contract, some obligation remains to be fulfilled. In other words, a contract is said to be executory when both the parties to a contract have not performed their obligation. According according to parties, unilateral contract. It is a one-sided contract. It is a contract where one party makes a promise in exchange for performance of a particular act by any party. Example: C promise to pay 1,000 rupees to anyone who pawned his lost bag. B pawned the bag and returned it to C. It is the unilateral contract which come into existence when the bag was pawned. Bilateral contract. It is two-sided contract. In this contract, both the parties exchange mutual for promises. Example: C promises to paint a picture for B, and B promises to pay 5,000 to C. It is bilateral contract. Yes, sir. देखिए देखिए हाँ, what do you do?